Hello everyone. Right to equality extends from Article 14 to 18. In Article 17 and 18, two specific provisions have been discussed. Article 17 speaks about abolition of untouchability and Article 18 speaks about abolition of titles. Coming to Article 17, untouchability is abolished and its practice in any form is forbidden. Any disability or any inability or disability which is enforced in any manner relating to untouchability is punishable by law. That means, if any person practices untouchability in any form, it does not specify what is untouchability or what is a practice of untouchability, or it does not define, but it says that in any form a person treats another person as an untouchable, or a person treats any other person by virtue of his being born in a particular caste as of a low status. In such cases, any practice, any manner of practice, any form of practice of treating anybody as of a lower status is forbidden. So, for this there is required to be a law and a punishment has to be prescribed under that law. For this purpose, the Parliament has enacted a law in 1955, that is the Prohibition of Untouchability Offences Act, the Untouchability Offences Act of 1955. This act was further renamed in 1976 as the Civil Rights Protection Act, that is Protection of Civil Rights Act of 1955. This is the name of the act at present. This was amended in 1976 because they wanted to give a specific meaning to what is a civil rights and define it, and also make the punishments more enforceable so that it is more effective. Now, they came up a case, that is a state of Karnataka versus Appa Balu Ingle, in which some people from a village prohibited or restricted one person from drawing the water from the well of that village on the ground that he was born in a particular caste. Now, whether this could be enforced against any persons is a question, because fundamental rights are enforceable against state action. So, here the Supreme Court said that practice of an untouchability in any form is prohibited. So, this article also gives protection against any person, not only the state, any person who practices untouchability in any form, and they were severely punished under the law. So, this is a landmark case relating to protection of Civil Rights Act and protection of or prohibition of untouchability under the Constitution. So, this is a specific social practice which should be eradicated from the society. That was the purpose of the founding fathers of our Constitution, to remove this particular social evil and see that equality is given its full and complete enforceability. So, equality has been treated as something which is very important, and a person has a right to live with his dignity in the society. He cannot be treated as of a lower status on ground of anything. It may be on the ground of caste or sex or religion or any other ground. So, this act or this particular provision goes along with the other provisions, that is 14, 15 and 16. Coming to Article 18, that is abolition of titles. Here there are 4 sub-articles, which first of all says no title of any kind, that is no title shall be conferred by the state except military or academic distinction. What is military or academic distinction? A person achieves a military rank because of his performance in the military. He achieves a distinction in his academic field by performing well in the academic field. He is given the degrees like a PhD and so on. So, these are not titles, because what is a title? A title is something which is an appendage to the name of a person. It runs sometimes in the family also. So, if a person is conferred as a title of a sir or a lord, these titles were conferred at the time of when India was under the colonial rule by the colonial masters, that is by the Britishers. They used to confer the titles upon certain persons. This has to be abolished. That is the purpose of this article. So, there shall be no distinction or no discrimination just because some title is appended to his name. So, this is the first article or sub article. The second subclause of Article 18 says that no citizen shall accept any title from any foreign state also. So, if any foreign state wants to give any title or confer any title upon an Indian citizen, a citizen of India shall not accept any title from any foreign state. So, this is a complete prohibition to see that the person is not brought against or made to owe allegiance to any foreign state again, as it happened at the time of the colonial rule again. So, this is the purpose of this act again. Subclause 3 says that no person who is not a citizen of India and who is holding an office of profit or trust under the state shall accept any title from any foreign state except with the consent of the President. That means, even if a foreign person or if a non-citizen who is in India, he is holding any office of profit or he is holding any office of trust under India, then if his state wants to confer any title or any foreign state wants to confer any title upon him also, he shall not accept the title unless he gets the consent of the President of India. So, he has to accept it only with the consent of the President, even if any foreign state confers a title upon him. This is the third subclause. The fourth subclause says that any person, whether he is a citizen or non-citizen, if he is holding any office of profit or trust under the state, then he shall not accept any present, any emolument or any office of any kind from or under any foreign state. This is a thing which says that even if a foreign state wants to confer any kind of honor or a emolument or a present for any services of a person who is an Indian or maybe a non-citizen also, if any foreign state wants to give any present or emolument or any office, then if he has to accept, he has to first obtain the consent of the President of India, and then only he can accept any present. So, the purpose again here is to see that all are treated equally. No title is appended to any name of a person, not only by our Indian government or by India, but by even foreign state. They cannot accept any titles by a foreign state also. So, these are the four subclauses of Article 18. Now, the question is, at the time of the Republic Day celebrations, the President of India confers national awards on certain people who have, certain persons who have given their services to the nation, maybe in the form of a specific performance or a particular excellence in a particular field like art, science or literature or public service. We call them as a Bhushan or Ratna of the society, Bharat Ratna, Padma Bhushan, Padma Vibhushan, Padma Shri. These are the awards which are national awards. Now, the question is whether these awards are titles and whether they are violative of the principles of equality which is stated in Article 18. There came up a case, Balaji Raghavan versus Union of India, in which this question came before the Supreme Court. And the Supreme Court has stated in this case that these national awards are not titles, they are not violative of principles of equality, basically because they are given not because they are just an appendage to the name or they are just a title, but they are given for their meritorious services to the nation. And therefore, they are something which is an honor to a citizen. They don't run in the family, and therefore they cannot be termed as titles in that term under Article 18. So, they are not violative of principles of inequality or principles of equality, and they do not promote any inequality. That was the judgment in this particular case. Now, when we look into these two articles, Articles 17 and 18, we can summarize that Article 17 is a guarantee that no person ever treats any other person of a lower, saying that he is of a lower status on the basis of his birth in a particular caste or in a particular class. So, untouchability is forbidden. It is made an offense. Article 18 again promotes equality by saying that no person can be stated to be something different from others by conferring title by the state. So, these are the two articles which go along with Article 14, 15 and 16. So, right to equality has a special meaning which is enshrined in our constitution to every person, not only every citizen, but every person in India. I hope you have learned something from this video. If you have liked it, please share it with anyone who you think would be interested. Please leave your comments and I would be happy to reply to them. Do subscribe to get more information on everyday law and legal studies. Thank you.